I welcome everybody. We're still getting folks coming into the meeting, so bear with us while we get everybody into the meeting. We'll start in a few minutes. So while people are coming in, let me explain that we'll have there's a Q&A feature in the Microsoft Teams webinar. So we're going to leave a lot of time for questions at the end. So as we're going through, we're going to hold all questions to the end, but if you put your questions in the Q&A, you should see that on the top of your screen, hopefully, and we'll go through. We did get a few questions before the webinar as well that we'll go into. All right, well, why don't we get started? I know people will continue to join, but let's get going. So welcome and thank you to everybody for showing up. We have a great turnout today, and we're hoping this will be an informative hour together discussing DEC's brand new freshwater wetlands regulations. We hope that this presentation will be useful not only to attorneys and wetland experts, but also for the municipal board members, planners, and resource specialists that deal with this stuff every day. We know that you're engaged in the process of permitting projects that have wetlands on the property, and we're happy to be here to talk you through what we're seeing with the new regulations and to answer questions that you may have. So as I explained, there's a Q&A function on the webinar, and we're going to leave a lot of time at the end to answer questions, and Greg and I are happy to stay on for longer than the hour if needed, if people are engaged in the conversation. So big thanks before we get started to Jack Quinn for his help organizing logistics for today's event, and he'll be helping behind the scenes here as we get the questions in. Next slide. So a couple of quick introductions. My name's Adam Stolorow. I'm a partner with Sive, Paget Riesel. I've got close to 20 years experience with wetlands, seeking local, state, and federal permits, responding to citizen suits and DEC enforcement cases. And I've often worked with Greg and his team at Capital Environmental as we navigate those sometimes tricky situations. Sive Paget does a ton of wetlands permitting work both around New York City and throughout the state. And I just wanted to note that I recently moved up to the Hudson Valley. So looking forward to doing more work in the Hudson Valley and up into the capital region. Greg?
Thank you, Adam. So my name is Greg Fleischer. I'm a professional wetland scientist and principal at Capital Environmental Consultants. It's a pleasure to be here with you all today to talk about wetland regulations. It's a pleasure to work with Adam and his team a lot. We do a lot of work in the Mid-Hudson Valley, a lot of work down in New York City. I had personally 20 plus years delineating freshwater and tidal wetlands, permitting wetlands for local, state, federal projects. And again, as Adam noted, we have worked together on numerous wetland related projects throughout the years.
Next slide. All right, let's start by going over some of the highlights of the new regulations. Next slide. So the new Part 664 regulations became effective on January 1st of this year. They were based on 2022 amendments to the Freshwater Wetlands Law. And now DEC has implemented these regulations to bring those laws into effect. The regulations significantly increased DEC's wetlands jurisdiction from about 1.2 million acres to 2.2 million acres. And one of the reasons we're seeing these new regulations are in response to changes in federal law. So EPA, which along with the Army Corps has responsibility for enforcing the federal wetlands laws and regulations under the Clean Water Act, estimates that federal jurisdiction has been reduced as a result of the Supreme Court case Sackett v. United States by about 1.2 million to 4.9 million miles of ephemeral streams, and up to 63% of the wetland acres that were formerly regulated under the Clean Water Act are no longer regulated as a result of Sackett. And now with the change in presidential administration, we've got the EPA coming out with some guidance last week, I think it was, basically saying that they're going to go even further in saying that the Clean Water Act doesn't apply to certain types of wetlands. So partly we're seeing these regulations as New York State sort of steps up to fill what it sees as a gap in federal regulations. And the new regulations feature major changes to the jurisdictional determination process, and we'll talk about all these things in detail. DEC has, just in the last couple of months, proposed new general permits that are meant to speed up the permitting process for certain types of projects. And these regulations really have significant differences between municipalities, from one municipality to another. And we're going to get into that as well. There are some exemptions from the new regulations. If a project that you're working on or that's being permitted prior to the start of this year received a freshwater wetlands permit from DEC, received notice from DEC that it had a complete freshwater wetlands application, is going through SECRA, and there's a FEIS that has been accepted as complete by the lead agency, or a NEGDEC, a negative declaration, was issued prior to the end of last year, or if a local land use agency or board has issued a site plan approval, those projects will be exempt from the new regulations for 2.5 to 3 years, depending on whether they fall within the definition of minor project or major project as defined in the DEC regulations. We had a couple of questions on these exemptions that we'll get into on the Q&A. Next slide.
So in identifying wetlands, the old hard copy maps are gone, but still used for informational purposes. What you're seeing on your screen is a representation from the DEC Environmental Resource Mapper. The green layer are previously mapped wetlands, which you would all be familiar with in looking at the resource mapper. The pink layer is a more informationally mapped wetlands. And you might be asking yourself, what is that all about? And what that layer does, that pink layer, is it incorporates many sources of information that DEC pulled together, including current aerial imagery, NWI wetland data, USGS maps, soil survey maps, and prior wetland delineation data. So again, previously mapped wetlands are still jurisdictional, and the new informational layer sort of does away with the 500-foot check zone that used to be on the ERM due to the increased accuracy of the remote mapping that DEC now has on the mapper. Next slide, please. So we're going to talk about jurisdictional determinations. This is a major change in the process. I'm going to just talk about parcel versus project determinations, how long a JD is valid for, which is 5 years, and then we'll talk about the appeals process. Next slide, please. So parcel determinations. Currently, the DEC now has an online submission form for parcel determinations, or JDs. What you do is you submit to the department online a request for the parcel jurisdictional determination, and you're really asking as to whether a given parcel of land includes freshwater wetlands or regulated adjacent areas subject to state regulation. The form where the JD is processed up in Albany, it does not go to your individual DEC regions. They have a crew of people that are processing JDs for all the regions, and then they they make their decisions based on the information that they have. The JDs are reviewed per a set of standard operating procedures, or SOPs. That's a public document. We're going to be providing a number of links during the presentation today, and that should be one of the links, hopefully, that we're going to be providing to you is DEC's standard operating procedures. The DEC determines the jurisdictional status of freshwater wetlands within areas of inquiry through remote analysis of GIS spatial data. And what they're really doing is taking all their GIS layers and they're quantifying what they're seeing around a given parcel as it relates to wetlands. And so they're looking at wetland acreage, they're looking to assess wetland locations within the watersheds, identify wetland characteristics that meet the classification and unusual importance criteria, which are two separate criteria, and indicate possible need for an extended adjacent area. Next slide, please. So project determination. So project jurisdictional determination means a determination that's made by the department as to whether a proposed activity within a parcel containing jurisdictional freshwater wetlands or regulated wetland adjacent areas requires a permit. So what they're going to need to do that, right? This is after you get a jurisdictional determination, is based on site-specific project plans. The delineation is either confirmed directly by DEC, delineated in the field by DEC and confirmed, or you have a consultant go out and delineate the line, and then have DEC come and confirm that delineation. So there's sort of a 90-day time limit for them to process your plans and the confirmed delineation to let you know whether you're going to need a permit. And that determination is valid for 5 years. Next slide, please.
So what happens if there's a jurisdictional determination and someone doesn't agree with the jurisdictional determination? Well, there's an appeals process that begins with an initial on-site consultation with DEC. Note that in doing a project JD, DEC has to have the permission of the landowner to go onto the site, and that's something that we had been asked about, and that people commenting on these regulations had asked about. So you start on site, you have a meeting, and then based on the results of that meeting, the person appealing the JD has 120 days to actually file a formal appeal, and then DEC has 60 days to issue its decision on that appeal. There are only three bases for an appeal. Either there was an omission of material fact, there was an incorrect application of the regulatory criteria leading up to DEC's jurisdictional determination, or there was an incorrect application of guidance for identifying or delineating the wetlands. So you're sort of limited to those three on your appeal. Next slide. Okay, now we're going to get into wetlands of unusual importance, which is a major feature of the new regulations. There's a lot of slides in this section we're going to try and cruise through quickly, but the big picture takeaway is that wetlands of unusual importance is an important concept because it's what gives DEC jurisdiction over wetlands that would otherwise be too small to meet the acreage requirements for DEC to take jurisdiction. So right now, DEC only has jurisdiction over wetlands that are 12.4 acres or larger. That's going to go down in 2028. That size limit will go down to 7.4 acres. But there's this whole other category and then subcategories within that of wetlands of unusual importance. And what does that mean? It means that any size wetlands could be a wetland of unusual importance under these criteria, and thus within DEC's jurisdiction. So yeah, go ahead, Jack. So here's the list. I'm not going to read them over because we're going to go through each of them. Next slide. Okay, the first two categories that we wanted to talk about are watersheds with significant flooding and wetlands in floodways. So both sort of flood related. The difference here is that one category number 1, watersheds with significant flooding, are based on analysis that DEC has done about certain watersheds, and that's what's shown on this slide in those blue areas. You'll see a lot of it's concentrated down towards New York City, and then a bunch out in Western New York. We put the links for both of these map sets, both the GIS maps for category number 1, and then category number 8. Those are federal maps. Those are FEMA floodways, so it's you go to a different website to look at those maps. But both of these are categories that you'll be able to check by looking at online maps. Next slide. The next one is urban areas. Again, this is based on GIS maps, and in this case, it's the 2020 U.S. Census Bureau data. We wanted to spend a little bit of time on this one in particular because it's going to trigger major changes from municipality to municipality that were not present under the former regulations. So as a result of the new regulations, wetlands in urban areas now fall under DEC jurisdiction regardless of their size. So these urban areas, as I mentioned, are based on US Census data, and there are some surprises as to where this applies. You'll see from the map on this slide that all of New York City is included, about 90% of Long Island, most of Westchester up into the Hudson Valley, from Newburgh up to Kingston, major parts of Sullivan County, the capital region, and then out to Utica, Syracuse, Rochester, and Buffalo. But a lot of those areas are areas you might think of as urban. You know, if somebody said, well, where are the urban areas in New York City? But then you get into smaller towns. You know, some smaller towns like in the Hudson Valley, like Claverack and Cairo, are considered urban areas. But then other ones that you might think of as towns that are sort of relative in size, like Chatham or Woodstock, are not considered urban areas. We go to the next slide. So here's an example of the GIS data for urban areas that I've overlaid using a mapping tool, focused on parts of Sullivan, Ulster, Putnam, and Dutchess counties here. And sometimes the urban areas literally cut right through a municipality. And one of the first things that'll be important to do if you're working in a municipality or working on permitting projects will be to look at these different map layers to figure out whether your parcel is jurisdictional. You know, even without asking DEC to do a remote jurisdiction, that maps like this one are going to help you know right away whether you might fall into the urban areas jurisdiction. And for people who work in the same municipalities on a regular basis, you'll be able to use this as a guide to just see whether, hey, does DEC have jurisdiction just based on the fact that it's in an urban area. Okay, next slide, please.
So to continue on with wetlands of unusual importance, we're going to next talk about rare plants and habitat for essential behavior or protected species. And I think what we tried to do with this portion of the presentation, as Adam sort of alluded to, is talk about how these types of areas of unusual importance are noted by DEC and what's their process. And I again want to refer to there is a standard operating procedure document, and a lot of the information I'm giving you here and Adam are giving you, it's from that document. So it can really kind of get granular for you if you want to look at that document further. So here, starting with rare plants and behavior for protected species, DEC will examine the parcel during a JD determination, and they'll compare it to wetland polygons in their database, and then most importantly, data found in a New York Natural Heritage Program element occurrence database, meaning that DEC has access to a database that is not public, with sort of point locations where they can then examine that against your parcel JD and any potential wetlands. Okay, I know it's kind of a lot to process, but that's sort of how they're going about doing this for JDs. And so rare plants just as a definition, would be it's a plant species occurring in fewer than 35 sites statewide or having fewer than 5,000 individuals statewide as documented by the department. Rare animals, a little more involved. It's defined as if it contains habitat that is utilized for an essential behavior of a species, listed as endangered, threatened in the Part 182 regulations by DEC, or listed as endangered by the United States Department of the Interior. It also can be considered habitat that is utilized for essential behavior of a species of greatest conservation need, listed in New York State Wildlife Action Plan. And that's a plan that was put out by DEC in September of 2015. And with having habitat loss been identified by the department as moderate to very high threat to New York populations. And you're all like, what did he just say? And so what it's really saying is there's this plan. There are some species that are identified in it that have a moderate to very high threat to New York populations. And in the SOPs, the standard operating procedures document, there's an Appendix D that gives you a very clear list of those species. So that's what you want to be looking at when you're evaluating these particular numbers 3 and 4 of unusual importance. So next up is 5 is Class 1 wetlands. Thank you, Jack, for moving to the next slide. So what DEC is doing there is they're reviewing the orientation of the digitized wetland areas within 100 feet of your parcel in relation to known locations containing any of the 9 Class 1 characteristics contained in their regulations for a Class 1 wetland. Wetlands containing known locations of or meeting any of the Class 1 characteristics are then jurisdictional. Number 6, previously designated as a wetland of unusual local importance. That's pretty straightforward. If you were in an area and the regs prior had identified it as unusual local importance, you're still jurisdictional. Number 9, previously mapped wetlands. We looked at that slide before that had the green polygons. Those are the polygons that represented previously mapped wetlands. Number 10, regional or local significance. A CEA, a critical environmental area with specific reference to wetland protection. So to not get super into it, but a critical environmental area that sort of has a component that references wetland protection would make that particular area jurisdictional. To assist with understanding where those are, which is very important for any municipality, Appendix E of the standard operating procedures list the known CEAs throughout the state. So it's a pretty comprehensive list from DEC. I think it's about 5 pages long. And that's something you can reference in that standard operating procedures document. Next slide, please. So vernal pools productive for amphibian breeding. A lot of information on vernal pools here, and I wanted to try to condense it. Basically, New York State determines a vernal pool is known to be productive for amphibian breeding within a region of the state based on numbers of egg masses. So depending on where you are in the state, if you're in the Hudson Mohawk region, the Great Lakes region, Lower Hudson, New York City, Long Island region, Adirondack Southern Tier, depending on the number of egg masses found for some of these particular vernal pool species, that's how they are sort of regulating or know it to be productive. The GIS process for that is they review the orientation of digitized wetland areas within 1,000 feet of indicated parcels in relation to the list of vernal pools known to be productive for amphibian breeding. And you're saying, well, where is that table or that database? That is obviously not accessible, as a lot of these species are threatened and endangered. So DEC has that. That's a tool that they'll use when you submit your JD. That's pretty much the process there. I know people have lots of questions about vernal pools, but that's basically, to sum it up, DEC has a database that they use, and they're going to compare that in the JD process to your parcel and wetlands near that parcel, and they'll use that to make a determination. And there is an Appendix E in the SOPs, standard operating procedures, but it's just a map. It's just showing you the different regions of the state. It doesn't really tell you any more information than that. So next slide, please. Okay, significant for protecting state's water quality. that's pretty straightforward. It's if it has significant importance to protecting the state's water quality based on substantial evidence as determined by the commissioner of the DEC in writing. That is what is stated for this particular category. So go to next slide, please. Okay, so general permits, in parentheses, proposed. A number of new general permits have been proposed, including one, a draft general permit for various activities within wetland and wetland adjacent areas. There's community scale solar energy, electric utility right-of-way maintenance and repair, housing development, lakes and shorelines, invasive species management, natural gas utility right-of-way maintenance and repair, and stream crossing for timber harvest general permits. Depending where you are in the state, you're probably loving that there's these general permits. They're going to really probably expedite the permitting process for lots of small scale projects. That's their intent, more or less. After the proposed general permits are issued, individuals will be required to submit a joint application form and a supplement form with supporting documents to obtain coverage under a general permit. To aid applicants, the supplemental forms will be available for each general permit to easily identify specific information needed to obtain coverage. Supporting documents will vary by general permit, but will include a location map, site photographs, and various plans and drawings, which is pretty standard for most permits for DEC. The housing development and renewable energy general permits will also require the preparation of wetland mitigation plans to compensate for permanent wetland impacts. So I would say before moving on from this slide, just everybody, a lot of municipal folks on this webinar, you're definitely going to want to pull up the permits and look at them and read through them and see how people are going to be, utilizing them within your municipalities for sure. Okay, next slide, please. So the first permit that was really issued after these new wetland mapping regulations came out, and I think I want to state very generally that the purpose of these general permits is to sort of alleviate the influx of anticipated permitting as a result of this mapping. We're going from, I think the numbers are 1.6 Adam to 2.6 million acres of wetlands that are now mapped in New York State. So I think that the idea is that these general permits are really going to help DEC process permits faster and not have such a delay for people that are applying for permits. So the first draft general permit, depending on the specific activity authorized, you really just the action can't result in a permanent and/or temporary disturbance totaling more than 1/10 of an acre to freshwater wetlands and totaling no more than 1/10 of an acre to freshwater wetland adjacent areas. This is a project that's, just like it says on the slide, good for repair and replacement, removal of existing structures, temporary installation of access roads and laydown areas, drilling test wells like soil borings for stormwater management practices, and things of that nature. So it's a good general permit, and it's an improvement over the original general permit, which, if some of you remember, was back from 2018, and even before that. I think it increases to a certain degree the amount of adjacent area, wetland adjacent area that can be disturbed in a lot of instances on a residential development. Okay, next slide, please. Okay, general permit for community scale solar energy installations, pretty straightforward. It's construction of temporary permanent access roads with limits, construction of power interconnections and collection lines, construction of solar energy infrastructure on existing structures in wetland adjacent areas, vegetation clearing, ground disturbance in wetland adjacent areas and areas under active agricultural use, and freshwater wetland mitigation and enhancement activities in jurisdictional areas. Next slide, please. So again, electric utility, right-of-way, maintenance, repair, again, pretty straightforward, self-explanatory. Construction of temporary access roads or laydown areas, maintenance and repair of existing functional structures, removal of debris, mechanical removal of vegetation, application of pesticides and surfactants. Natural gas utility right-of-way, again, a lot of this has to do with temporary access, laydown areas, maintenance and repair, mechanical removal of existing vegetation. These are all the theme here is that these are all common practices associated with these particular permits or uses. And so DEC is trying to streamline the permitting process for the most common types of permits requested. Next slide, please. So housing developments. This is an interesting one. I think it's most certainly going to apply to a lot of folks on this webinar. You're going to see this in your municipalities. It relates to construction of single-family housing and multiple family dwellings, repair or maintenance of utility lines, repair or maintenance of stormwater outfalls, water wells, repair, reconstruction, replacement of existing septic systems. Again, testing, test wells, and geotechnical, and impacts associated with compensatory mitigation. This is designed to help, again, with probably some of the most common types of housing developments, be they small or large. It does sort of address both single family units, multifamily units. And I think the takeaway from this is that DEC is anticipating that these types of permits are going to have some type, in a lot of instances, potentially wetland impacts, small wetland impacts, and small adjacent area impacts. And so again, to limit the amount of time spent permitting, they're issuing this general permit with a number of restrictions. I would say this one probably has the most restrictions out of all the general permits. Restrictions to note that some of you might be pretty familiar with are time of year activity restrictions for fisheries and for tree removal, and that's related to bats. We're all on this webinar familiar with bats and tree removal, I am certain. Attachment A is a worksheet that's at the back of the permit, and it's called the Unavoidable Impact and Mitigation Worksheet. And that's used to demonstrate that impacts have been avoided and minimized to the extent practicable. And that's, so it's like, it's a mathematical worksheet that you work through, and it kind of, by doing it based on the size of your parcel, and the amount of proposed disturbance, you come up with an area that you can essentially disturb as part of the general permit. It's a little convoluted, but I think once you work through it, it becomes pretty straightforward. Next slide, please. Lakes and shorelines, GP 2507. I'm just going to read through some of these. Shoreline erosion protection, utilizing bioengineering, shoreline installation of new riprap, replacement and repair of existing functional riprap bulkheads, bank stabilization, shore installation of new stepped block walls, in-kind replacement or repair of existing boater access ramps, new single-lane boater access ramps, and in-kind repair or replacement of existing functional boathouses. Next slide, please. Installation of a new residential dock, less than 400 square feet, demo of existing structures, removal of fill, maintenance and dredging, new navigational dredging activities around existing docks, installation of maintenance of dry hydrants, of new replacement water intake lines, and then physical removal of submerged or floating aquatic vegetation, less than 1,500 square feet. These are, again, probably some of the most common permits that are typically issued by the department around lakes and shorelines, and now they're trying to, with a series of conditions, trying to truncate that permit time, that permit, putting together a permit, processing a permit, and then issuing a permit. The general permits are designed to save time sort of for everybody while still evaluating natural resources to the extent that they need to. Next slide, please. So management of invasive species. So I think we went too far on one. Did I miss that? You go back one. Thank you. So management of invasive species, hand harvesting techniques, suction harvesting techniques, aquatic pesticides within areas previously treated within the past 4 years, benthic barriers, mechanical harvesting or cutting, and may include native nuisance species management. That's going to, again, be useful to some specific regions of the state, I'm sure, where they're looking to manage, invasive species. So next slide, please.
Okay, the last thing that we wanted to talk about before we get into some Q&A is the impact of these regulations on local wetlands permitting. And we know that many municipalities have their own wetlands laws requiring project applicants to obtain not just state or federal permits, but also local permits. these laws are required to be at least as protective as the DEC regulations. So in the past, because of the DEC size limitation on what the state regulated at 12.4 acres, a lot of local laws, regulated smaller wetlands that weren't regulated by the state. In many cases, you've got local laws that have larger wetland adjacent areas than the DEC standard 100-foot adjacent area, or where there are additional local restrictions on the types of disturbance or types of activities that can take place within adjacent areas to wetlands. So now that these new regulations are out there, it's probably worth reviewing your local laws against the new regulations. One, to figure out whether the new DEC regulations make the local laws redundant. Has DEC really stepped in a way that those smaller wetlands are going to be sufficiently protected at the state level? And there may be some questions about what exactly it is that the local laws do, particularly in urban areas where DEC is going to be regulating basically all the wetlands in those urban areas. And second, you might want to look to make sure that the local laws are still at least as protective as the DEC regulations. And there may be some cases where local laws that were previously more protective than the DEC regulations now may be not more protective. So if you have a municipality out there that does not have wetlands and watercourse protection laws in place, it's something that Greg and I would be happy to work with you on, or to connect you with the resources for model laws and things like that to put local laws into place. Two issues that I wanted to bring up that could change the effect of DEC's regulations at the local level. One is critical environmental areas. Critical environmental areas are one of the ways that local municipalities can designate environmentally important areas. Typically, this has been through the secret process, where a critical environmental area can trigger a higher level of scrutiny or protection for activities taking place there. Mm-hmm. But now you've got, under the new DEC wetlands regulations, the CEA putting an area of a municipality into a CEA based on its wetland characteristics makes it a wetland of unusual importance. So if you had a municipality that, for instance, just wanted to say we view all of the wetlands in our municipality as critical environmental areas, you could put a CEA into place, and that would basically bring all of your local wetlands under DEC permitting jurisdiction. The other aspect that I wanted to bring up, and this is a not very widely used part of the DEC regulations, but there is under Part 665 of the wetland regulations a provision for the local assumption of DEC permitting authority. This is similar to the way that you have state level Clean Water Act permits, even though it's a federal law. So when you go to get a state Clean Water Act discharge for stormwater or industrial discharge, those are really federal laws that are getting permitted through the state. And there is a provision in state law that also allows the state to delegate its permitting authority to a local municipality. That it hasn't been widely used, but maybe this is something now that that there's more and more jurisdiction that overlaps between the state and local permitting authorities, where you might have some municipalities who say, hey, we've gotten pretty used to issuing wetlands permits, and we're happy to be the local resource that knows the wetlands better and wants to carry out this permitting activity. And that's something we could discuss as well. If anyone's on the webinar today who has experience with this, with a municipality, I'd love to hear more about it. It appears to us that it's not very widely used, but maybe it's something that more municipalities will want to explore given the new regulations. Next slide. Okay, so this slide, when we send out the slides, these are all links to various resources that we've discussed on the webinar today. We've got the regulations themselves, the text of the new regulations, the DEC environmental resource mapper. That's the one that we used to show those green and pink areas of wetlands that are shown up on the DEC maps. We've got a link to the DEC standard operating procedures. Those are the SOPs that DEC staff look to when they're making their jurisdictional determinations. We've got a link to the proposed general permits that Greg talked through. The GEIS clearinghouse. This is a question we got about how people could access the data that we were showing, for instance, on the urban areas. The GIS clearinghouse has files that you can download that contain that data. So that overlay that I was showing that had the purple sort of outlines around the urban areas, that was a file that I pulled off of the GIS clearinghouse and then uploaded to a mapping software that we use. And so all the different layers are on there, including the watersheds with significant flooding and things like that. And then we've got a link to the FEMA flood maps. Next slide. Okay, that brings us to questions. We've still got about 20 minutes to talk through some questions. We did receive a few questions before the webinar, and so maybe we'll start with those, and then we've got some questions coming in the Q&A that we'll get to as well. So Greg, do you want to start off with some of the questions that we received?
I would be happy to. First question, are paved roads built inside the 100-foot wetland buffer allowed in the state of New York? And the answer to that is construction of roads is a regulated activity within wetland adjacent areas. Second question, can you bring in fill if you are in the freshwater wetland buffer? Filling is also a regulated activity both within the wetland itself and within the wetland adjacent area.
All right. One of the other ones we got was, under what circumstances should a planning board require an applicant to get a JD under the new system? And I think every project is different here, but planning boards frequently require applicants to get necessary permits from the state as a condition of building permit issuance. So boards may want to include this as a condition of approval in their site plan approval, for example. So, for example, you might say, unless, as a condition of approval, you might say something like, unless DEC issues a freshwater wetlands jurisdictional determination that says DEC does not have jurisdiction, the applicant shall obtain any necessary DEC freshwater wetlands permit prior to the issuance of a building permit. So that, it really is going to depend on the applicant as to where they want to spend that time and resource getting the jurisdictional determination. You may have applicants who come into the process already having gone to DEC and gone through that process. You might have others that, want to advance the project with the planning board before they get their jurisdictional determination. It's for every project applicant, it's going to take time and resources to go through that process. And, some people may want to front load it before they go to the planning board, but I don't know that as a planning board, I would say, don't come to us unless you have a JD done. I think I would sort of leave it up to the applicant as to when to do that, with the understanding that no on-site disturbance is going to be allowed until the appropriate permits are in place. Greg, do you want to go over to some of the questions we're getting in?
Yes, let's do that. You want to just go from the bottom up?
Sure. So I'm looking at the published ones here.
It's first one is 17 minutes ago. That one similar to the proposed. Yep. Okay, so similar to the proposed general permits aimed at reducing the regulatory burden on largely non-restoration activities. Are there any known efforts to improve the permitting process for ecological restoration projects?
I can take this one. Yeah. So there are no specific general permits that are that are aimed at restoration. Unlike the Army Corps general permits that do have some that are targeted at restoration activities. However, there are some features of a couple of the general permits that do discuss restoration. For example, in the proposed housing development general permit and the community scale solar permits, those permits authorize impacts to wetlands and adjacent areas that are associated with compensatory mitigation projects. And so, for instance, you're going to get a general permit, but it's going to say if you're disturbing in the wetlands or in the adjacent area, you have to mitigate by restoring, compensating for that disturbance in some particular ratio elsewhere on the property or nearby. So those activities, the actual restoration part of those permits is covered under those general permits.
I feel like you just answered the next question in the lineup there. Am I crazy? I think you did there.
Let's see. Yeah, that does sort of get to that one. So the question was, if given a general permit, will mandates to return the land to its original or better condition be included? Can DEC require wetland, I think that was supposed to be creation elsewhere in areas that are disturbed? Ideally, any disturbed areas should be doubled and recreated, or make the cost, or are the costs of the permit significantly higher? So yeah, typically DEC is going to want mitigation. Sometimes that ratio is 1-to-1, sometimes it's 2-to-1. And they're going to want it to be as close to the project as possible. So ideally, that mitigation takes place on the same site in an area. You're going to disturb one part of the parcel for your project, but on another part of the parcel, you'll create wetlands so that there's not a net loss of wetlands.
Okay. Next question is, we're in the process of overhauling our town's comprehensive plan. Is there anything in specific we should address given the new regulations?
Yeah, I can take this one too. I think, I guess if you're in the comp plan process, you want to, maybe that's a good opportunity to look at what's on the books right now in terms of your wetlands laws and look at the new regulations and spend some time thinking about, whether the municipality wants to do more in terms of regulating wetlands. And just, it might be a good opportunity to sort of refresh what's on the books and see, in light of the new DEC regulations, whether the municipality wants to do more or less. It may be that the municipality looks at the new DEC regulations and says, we could streamline our permitting processes by allowing, DEC to take the lead on wetlands permitting, and we'll focus on other things. So I do think as part of a comp plan that there is room for that kind of exercise.
Okay. I do have a follow-up question to the original question.
Okay.
Before it goes, so the question before was similar to the proposed general permits aimed at reducing the regulatory burden on largely non-restoration activities. That was that question. And what the questioner asks is, I was referring to voluntary restoration projects rather than compensatory mitigation. Be helpful if I read the question to you one more time.
No, I got it. So, so the answer is no. There is not a general permit that covers voluntary wetland restoration, unlike in the federal context where the Army Corps does have those kind of general permits.
Okay. Right.
All right, Greg, let's see if we have one for you here. Is the state adding manpower as they increase their jurisdiction and pulling back on their maps?
That's a great question. What the state is reporting in a lot of their informational seminars is that they've centralized the review of jurisdictional determinations in Albany. There's new hires. I think it's a group of maybe 3 to 10 folks, 3 to 10 people that are processing these JDs for all the different regions. So the thought is that that should alleviate some of the pressure on some of the regional folks to have to perform those jurisdictional determinations.
Right. Okay, this next one, I'm not doing a very good job publishing these. Okay, what is the DEC process for handling wetlands of unusual importance that may render a lot unbuildable due to the adjacent area? For example, in an urban area where a wetland is delineated that was not previously jurisdictional, on a small lot, the jurisdictional area may fully encompass the site thought to be buildable. So what's the DEC process for handling that? Greg, you've got a client and they have a wetland that takes up half of their property, and with the adjacent area, what's left? How do you deal with that?
I can speak a little bit from experience on this. I had a similar case recently. This is what I can tell you, and it's a little generalized the answer, but if you're finding that you had a site that had no DEC wetlands or wetland adjacent area, and now you have informational maps that are showing a potential, right, because it's not been verified yet, a potential wetland, and then subsequently wetland adjacent area on a site, the first thing you really need to do is, it's twofold. You can have a consultant or somebody delineate it for you and really get a good assessment of what's there, or you can go through the JD process with DEC to see if in fact they're going to review that your parcel and say and agree with the informational wetlands and things of that nature. In the end, I think DECs, and I'm not a representative of DEC, I don't speak for them, but I think their position is that they understand that these rules and regulations just came out on January 1st of this year, and you're just seeing these maps January 1st of this year. And I think in that sense, they're willing to probably work with applicants that are just now seeing the potential for wetland jurisdiction on their properties. It's a little bit of a general answer, but
we hope.
Yeah, but I think that's what they're looking to
do. All right, I'll take this next one. If it says if an applicant has already received a JD and neg deck, but not yet obtained a site plan approval or building permit, can a planning board lawfully request a new JD under the new regulations? It says the project is in an urban area with vernal pools. All right, so if you the list of exemptions under which projects that were already in progress are grandfathered is those bullets. If you hit any one of those bullets, you have an exemption. So if you have already received a JD and neg deck, the neg deck is going to get you an exemption. So if you have a negative declaration through the secret process as of December 31st, 2024, you are exempt. That project is exempt from meeting the new regulations until 2027 or 2028, depending on whether it's a minor project or a major project. So you have that period to sort of get your project done before that area would become jurisdictional.
I would add to that, Adam. It kind of dovetails with what I was talking about just before. Like, I think DEC is gonna work with. I think they're definitely prepared to work with folks that are in the midst of a municipal approval process. Halfway along, 3/4 of the way along, and they don't have some of those determinations that give them exemptions. I think the DEC is probably looking to work with them, understanding that if they now find themselves with informational map wetlands on their property where they didn't before, if they're basically have almost significantly gone through seeker, I think the department understands that and is probably sympathetic to that, I would guess.
Yeah, and I should note also that if you're in an urban area with vernal pools and you're, you get to say, well, I got my neg deck, I'm exempt from DEC permitting. If you're in an urban area that has local laws related to vernal pools that protect vernal pools as wetlands, you still have to get whatever local permits you might have needed. I mean, maybe you're in an urban area that doesn't have laws related to vernal pools, but again, these exemptions only deal with the state permitting. They don't. It doesn't give you a pass from local permitting on vernal pools. All right, Greg, I've got one for you here. Many solar arrays do not physically disturb the host wetlands, but the solar developer removes the trees surrounding the wetlands and water bodies, thereby raising the water temperature and killing wildlife. This needs to be addressed before permitting. So what happens in those cases where you're not there? There's I guess I would say this is like an indirect impact to a wetland.
Yeah.
You run into this?
I mean, it's an accurate statement. I imagine, and I will be the first to admit to, I didn't read in detail what the new general permits for solar arrays and things like that, like and for solar installations, um, that were sort of promulgated, like what they state. But I imagine, I know that's a concern of the department. Like whenever you're dealing anywhere near wetlands these days, is tree removal in relation to increasing, temperatures on a water course or a water body because of removal. And the same would go for solar installations. So I think the thing to do would be first review the general permit and see what that says about such situations. But it's definitely something to raise. I mean, you can raise it within your municipality, and you can raise it with DEC as well in your reviews.
I mean, putting my sort of project opponent hat on here, it's something that if it was creating an impact in the wetland, but it was whatever's happening is outside of DEC's jurisdictional area, I think that's the kind of thing that you would argue should be covered under the seeker review. So it sort of becomes a seeker question rather than a wetlands permitting question per se.
If you're outside the adjacent
Yeah.
area, you're saying if you're outside the
Yeah.
adjacent area, that's a good point.
Yeah.
Yeah.
We've got a question here. Once DEC says that an applicant needs a JD, would it be against New York state law not to follow that process? So under the new regs, you need to check to see, if you've got wetlands on the property, you need to check to see whether they are state jurisdictional. And once it's determined that there are jurisdictional wetlands, you need to follow the process and get a permit. Otherwise, you'd be building or whatever it is you're doing on that property without the proper permit. Okay. This is another one on exemptions. What if the planning board project was previously mapped / delineated wetland, it was mapped, and it's now a hit for the informational? In other words, you had a delineated wetland, but now you pull up the DEC ERM mapper and it shows your property is in the pink zone. Would it need to be remapped?
So the DEC, I just want to make sure I understand. So the DEC, through their informational polygon, is confirming what you know to be on your site. And then what's the follow-up part of that? Is
would it need to be remapped?
Maybe I'm not following that correct.
I think it depends. Again, this is like sort of another exemptions question. Like, it depends on where you are within process. So the question says, what if the planning board project was previously mapped / delineated? Well, if it got a jurisdictional determination, that's still not enough, right? You have to have fallen under one of those categories. So if the project got a DEC wetlands permit, you're exempt. This is, prior to December 31st. If DEC acknowledged the freshwater wetlands permit application as complete, you're exempt. But just a delineation, you're not necessarily gonna have to go back and redelineate, but you will have to follow the new process, and you may potentially have to get a DEC permit.
That's an excellent answer. I'm now following what you were asking. Sorry, I didn't catch that at the beginning. Sorry. It's a great answer.
All right, this is a question that actually came in before the webinar also. It may be the same person asking or just a similar question. And that is, if you have a site plan approval and you're looking to modify the site plan, are you exempt, or does that put you under the new regs? And in thinking about this question before the webinar, I think you can make an argument either way. So all right, so one of the exemptions is you had a local site plan approval prior to December 31st. Okay. Because those exemptions sort of are also tied to SECRA, I would look at it sort of through a SECRA lens. So you've got a site plan approval, you've got to come back. You're also going to have to think about SECRA. Like, does the modification to your project result in a change that would require you to do new SECRA analysis? And if so, I think you also may need to go under the new regs. However, if the I think that's an argument anyway. I'm not sure that there's a clear answer to this one. Because if it's a major amendment, the planning board's being asked to take a new action, it's going to have to comply with SECRA. Yeah, so I think that's the way you look at it, is does it require a new analysis, or is the change really minor enough that there's not a new impact to wetlands? That's the way I would argue it, I think, is like what kind of change are we talking about? Maybe that modified site plan has nothing to do with wetlands, right? Maybe it's a major amendment, but like the reason that it's a major amendment doesn't have anything to do with wetlands. So I think it's a little bit of a gray area, but I can see sort of different ways to argue that. All right, we are at 3 o'clock, and it looks like questions have slowed. We still have some people. We have some questions that we got before the event that we could continue on, or we got a new one here. All right. If a project contains a delineated wetland, this one's for you, Greg, or contains hydric soils, but it is not picked up on the DEC informational layer, is a JD required?
Ooh, well, that would make the assumption that it's not mapped locally, that it's not mapped federally. Is it regulated? Well, it's a great question. I mean, ostensibly, if you have the potential for wetlands on your site, you're going to have a consultant go out and delineate wetlands on your site, and they would flag that. So I think just because it's not there doesn't mean it's not regulated. I think wetlands are regulated. It's up to the municipality how they want to pursue that particular situation. It's a tricky situation, but theoretically, yeah. I mean, if you're going through a SECRA process and you're evaluating, say, natural resources, the town should say, or the municipality should say, what's it like for wetlands out there? I'm looking at an aerial and I see this, and then you should be able to account for that.
I think if the question starts out by saying if a project contains a delineated wetland, I think you have to go through the JD process. You start with the parcel. You start with the parcel determination, which is a 90-day, at the max a 90-day process, and it's done remotely by DEC. So in this case, you just ask, start by asking DEC, what do you, it's not on the question sort of has the premise like it's not on the ERM mapper in pink. It's not showing as something that DEC has their eye on, but you would want to go through the process anyway, because you're starting with something where some wetlands consultant has gone out and said, there's a delineated wetland here. So yeah. I think you do go through the process.
That's a great point too. That's a good point, because they're gonna be looking at those same aerials. You can approach that from different angles there. I get that.
Yeah. We got a question. Are you able to provide these valuable slides to attendees for future reference? And we will send out the slide deck that we used today. And we're also going to put together a sheet that has the question and answers that we discussed today, so that everybody has those, and it'll have our contact and information and things like that. We've also been batting around the idea of doing a follow-up presentation on this, sort of focused more from the developer's perspective or applicant's perspective. So maybe we'll have another opportunity to talk through some of these really interesting issues under the new regulations. But with that, I think we'll say thank you to everybody for attending. This was a really great turnout, and we hope it was informative.
Yeah. Thank you all. Good job,
Thanks.
Adam. Thank you. Thank you, Jack.